Good afternoon. My name's Wally Holohan. For those of you that don't know me, I teach or co-teach the Prisoner's Rights course with Patty Garin. I'm also on the committee that picks the Daynard and the Developer Fellows. I think we did a great job this time in the past in picking Patty Garin. I hope those of you that were at her presentation and had an opportunity to meet with her gained a lot of insight into what it takes to become a lawyer like Patty. Before I go into the presentation today, I'd like the people that are on the committee, the students, to stand up for a minute, that are on the Gavelba or Daynard. I'd like to acknowledge in all the help that they do and all the work that they do to find people like Patty and the panelists here today and to put on these presentations. Lucy is a great leader and does a wonderful job keeping us on point, but the real credit in these kind of presentations are the students on the committee. So the other reason I had them stand up today is if you have any ideas in terms of who we should get in the future, what kind of topics you want to learn about, what kind of lawyers you want to learn from, just contact your representatives on the committee, and certainly we'll be glad to look for that lawyer or at that topic. So thank you. So today we're going to continue the presentation that Patty gave on Wednesday about trying to stem the enormous increase in the number of people going to prison, both here in Massachusetts and across the nation, but particularly persons of color, both kids as well as adults in this prison system. The panelists we have today are wonderful lawyers that have spent countless hours and many years trying to stem that flow of people from schools or into the prison system by using the law to make systemic changes in terms of how long people are put in prison, what they're put in prison for, and to get people out of prison earlier. Today we have three wonderful panelists with us. The first panelist is Ducey Concaves. Am I pronouncing that?
Almost. Ducey Gonsalves.
Oh, thank you.
Nice
is a lawyer who's in charge of the Quincy office of the Youth Advocacy Department for the Committee for Public Counsel Services, which is the Public Defenders of Massachusetts. She represents juveniles in delinquency and youth offender proceedings. In Massachusetts, youth offenders are the kids that are tried as adults. She appears in proceedings in Dorchester, West Roxbury, and Boston juvenile courts. And she's an NU grad of 2005.
Yes.
The next panelist is Lael Chester. Lael is the executive director of the Citizens for Juvenile Justice, where for the past 10 years she has directed and promoted juvenile justice initiatives, overseeing juvenile justice research, law reform, and lobbying. She is a graduate of Harvard Law School. Last is Beth Eisenberg. Beth is a 1989 graduate of NU. I worked with Beth when she was a student here. She's now the director of the Special Litigation Unit for the Committee for Public Counsel Services. She's done amazing litigation, both at the trial level and particularly at the appellate level, in bringing constitutional challenges to the ways people are treated both on probation, parole, and in prison. Patty's now going to introduce the members of the panel to you. Thanks.
Well, we're just going to go in order, and we're each going to speak 15, 20 minutes or so, and then we're going to open it up to questions, because I've been meeting with a lot of you all week, and you're just full of questions. So here's a whole panel can give you some answers to those things. So we'll start with Ducey.
Thanks, Patty. Hello, everyone. Good afternoon, and thank you for having us here today. Before I get started about the particular topic that I'm going to talk about, I'm going to ask some people to think back to their childhood years, those adolescent years. And I know for some of us that's thinking a little deeper. For that gentleman way back there, he's going to have to think a lot deeper, right? So think about the times where, you know, you may have been at home and...
That's Ducci's boss, so don't worry.
I get to say that. You may have been at home and you got in a fight with a sibling and you may have pushed them or even punched them. Or you may have been slamming things around the house, yelling at a parent. Or think about a time that you were in school and maybe you were frustrated and you slammed your book on top of the table or slammed a door. These are all things that happen as we're children and growing up and developing into young adults. There's experiences that you have. Now, do any of you guys think those are crimes? Well, those are some of the types of cases that I have in court. And I'm telling you, as a kid, I have a twin brother. We fought probably every single day up until we were probably like 13 or 14. And, you know, I slugged him here and there, and we fought over the remote control, whose ice cream was in the refrigerator, who had the last one. These are things that we fought about all the time. And can you imagine being hauled into court and having your family brought into court for these kinds of sort of normal adolescent behaviors? You know, these are kinds of cases where children are being charged with assault and batteries, assault and battery, dangerous weapon, disturbing the peace, disturbing school assembly. We are criminalizing adolescent behavior. So all kids, and you don't have to tell me what you did as a child, but all kids commit crimes. But there's only some kids being brought into the juvenile justice system. And in our society, we have these systems, interlocking systems that, you know, just work in a way where children of color are poor and they're in school systems not designed to meet their educational needs. And because of this, these kids are funneled through our system, into the child welfare system, into the juvenile justice system, and unfortunately later into the adult criminal justice system. Now, contrary to what people may think or what is portrayed in our society, children of color are not committing more crimes than other people. And I'm going to share with you some statistics. The National Household Survey on Drug Abuse Reports conducted a study in 1999, and the studies show that youth of color are treated more harshly than white youth, even when arrested and prosecuted for the same offense. For example, white youth are more than a third more likely to have sold drugs than African American youth, but African American youth are arrested at twice the rate of whites and represent nearly half, 48%, of all youth incarcerated for a drug offense in the juvenile justice system. Another statistic, 45%, this was done by the National Center for Juvenile Justice in 2008. 45% of all incarcerated youth are African American, 30% are white, and 1/4, 25%, are Hispanic. So I share these statistics with you not to say that, okay, because children of color are not committing more crimes but are punished more severely, then we should do the same to white children. That's not at all what I'm saying. I'm sharing this with you to say to you that they should have the same benefits. There's different policing practices in other communities. The education systems in other communities are very different. And education is crucial. The lack of academic achievement is one of the leading factors that leads to chronic court involvement. And I want to spend a few minutes to talk to you guys about the school to prison pipeline. Has anyone heard of that before? Okay, so most people. Well, it refers to the huge number of students that we have, and there's a disproportionate number of students of color being treated like they're disposable and just being pushed out of the school systems and toward the juvenile and adult criminal justice system. And there's several reasons for this. We have failing public schools that are overcrowded, lack of funding and resources, and lack of extracurricular activities. So we're locking our students into a second-rate education. I'm sure some of you have heard of the zero tolerance policies. Students are being pushed out that way. Schools are having no sort of tolerance for any of, again, that normal adolescent behavior that we know all children engage in and is part of their normal development. And they actually are imposing harsher punishments regardless of the circumstances. Actually, the rates of suspension have increased dramatically in recent years, from 1.7 million in 1974 to 3.1 million in 2000, and have most been dramatic for children of color. Again, I like statistics, so I'm going to share some more with you. African American students are far more likely than their white peers to be suspended, expelled, or arrested for the same conduct. There is no evidence that students of color misbehave to a greater degree than white students. They are, however, punished more severely, often for behaviors that are less serious. And these statistics are from, this is from the Zero Tolerance, Zero Evidence, an analysis of school disciplinary practice, which was done by the Indiana Education Policy Center. So we know that kids are being pushed out of school systems and being funneled through into the juvenile justice system. And so what do we do about it? Well, here in Massachusetts, fortunately, we have the Youth Advocacy Department. Now, I'm not just saying that because I work for the Youth Advocacy Department. And here in Massachusetts, as was stated earlier, we have the Committee for Public Counsel Services, which is the State Public Defender's Office. And within that, there's the Youth Advocacy Department, which are public defenders who specialize in juvenile representation. And so initially there was one office that started out in Roxbury, and then there was an office in Worcester. Over the last year, 6 other offices have opened up, one in Springfield, one in New Bedford Fall River, one in Quincy, and that's my office, and we cover Plymouth County and Norfolk County. And those of you who are not really from Massachusetts, that's the southeast region, so Brockton and Quincy courts. There's also an office in Somerville, there's an office in Salem, and an office also in Lowell. And these offices have most of the offices have 4 attorneys and a social service advocate. And 2 of the attorneys are more experienced attorneys, and then we have some more entry-level attorneys. And now, being a juvenile defender, it's much more than the legal case. As Patty, I think, talked to you earlier, as public defenders, part of our job is the legal representation and ensuring that our clients get quality representation. But in the juvenile world, you have that piece of it, but it's much more broader. You have to be experts not only in the law of criminal law, but also in the youth development approach. Now, has anybody ever heard of the youth development approach? All right. I'm going to give you a definition. It's from the Medical Foundation, the BEST Initiative. It's a simple set of concepts and strategies that help adults better understand and support youth in developing the personal, social, academic, and citizenship competencies necessary for adolescence and adult life based on their capacities, strengths, and formative needs. So what does that all mean? Well, there's 5 domains, and those 5 domains are health, safety, relationships, education and work, and community. And what we try to do in our legal representation of juveniles is, as I said, the legal work in the courtroom, whether or not we're filing a motion to dismiss, a motion to suppress, trial prep work. But also, how can we best support these children in these domains to ensure that they have good life outcomes, which will lead to good legal outcomes for us. And so we have social service advocates in our office who help in the educational realm of things. Are these students not getting the appropriate education? Are they special ed students? How are they being disciplined? What's going on at home? How can we help there? What about in the community? Are they linked with a mentor, a community-based organization, an after-school program, a local YMCA? Are they having problems commuting to school because of safety reasons or going to other pro-social activities because of safety reasons? And how can we help there? Do they have a primary care physician? Do they have health insurance? These are all sorts of things that we have to think about when we're working with children to ensure that they're going to get the best outcomes. And additionally, once these kids are funneled through that system into the juvenile justice system, there's lots of consequences for a kid who walks inside of a juvenile court. Now, I'm going to ask you guys a question. How many people think a child in Massachusetts who gets suspended from school for a felony charge that occurs at school, how many people here think that a school can suspend someone for a felony charge that happens at school? So a kid is at school and they bring a weapon to school. Can they get suspended? Yeah, okay. What about, it's a Saturday night and you have, what's your name? Steve. Well, when Steve was 16, it was Saturday night, and Steve, you were at a party. And things got a little crazy, Steve, and there was a fight, and now you're charged with a whole bunch of things, assault and battery, dangerous weapon, and there's a list of charges, and one of those charges is a felony charge. Saturday night, 11 o'clock, Steve, you're not out that late. It's 11 o'clock. Can Steve's school, Northeastern High School, a Boston public school, can Steve's school suspend him? How many people say yes? How many people say no? So a few of you say no. In Massachusetts, for a felony charge, just being charged with something, that's a felony, that happens off school grounds, that happens on a Saturday night, you can be excluded from school for that. The school has to show that your continued presence in that school creates a substantial detriment to the general welfare of the school. So not only are our offices doing that legal case, because now we got to represent Steve. We're in court and we're in Boston Juvenile Court on these charges. Now we're coming to Northeastern High School and fighting for Steve to ensure that the school is not going to kick him out, and if they do, what are our options? So again, just giving you a picture of the kind of work that goes into juvenile representation. It's just not the legal case, and it's much broader. So I just gave a school example, but as I said, once you walk into that courthouse, there are all other kinds of consequences depending on how that case is resolved. It could mean sentencing enhancements. It could mean, issues with if you wanted to go into military service, your driver's license, immigration, public housing. If you're charged with a sexual offense, it could mean sex offender registration. There's just so much more that goes into that. And so I share that with you to sort of give you an idea and paint a picture of sort of the wider range of advocacy that's necessary to get the best legal outcomes. And again, as I stated, education is crucial to this because the lack of an appropriate academic education starts to send kids down this pipeline, down to the juvenile justice system and then unfortunately to the adult system. So I feel like myself and the people in my office, we have a very important job. And, I wouldn't choose to do anything else. I love the work that we do. It's, as I said, challenging in terms of the legal aspect of it, all the things that you guys are learning in your first year. Are you guys taking crim law yet? Okay. Next semester, when you get there and you're taking crim law and you learn about all the constitutional rights that individuals have, and these rights apply to children. When you start to learn about those things, those are things that we have to do, but I wanted to give you a bigger picture of those other things, the collateral consequences, and also the educational piece of it for children. So I think I've talked my 15 minutes, so I'm going to move it along.
Okay.
Thank you.
Thanks, Ducci. And there'll be plenty of time to ask questions because I think that Ducci can also talk about when we're talking in general later on about all the different players in the system that she touches that are lawyers so that you don't have to absolutely be a public defender to help children. There's lots of other lawyers along the way, and we'll talk about that in a minute, but there's school lawyers that can do the right thing, and there's other people in the system that can step in and do the right thing. So that's some public interest work from a public defender who represents individuals. And a lot of you ask me questions in meetings about, if I don't want to litigate, can I do reform work? Can I do public interest work? What can I do if I don't want to be in the courtroom litigating all the time? And Leo is an executive director of a nonprofit that does fabulous advocacy work on behalf of juveniles. So she's going to talk to you a little bit about Citizens for Juvenile Justice and the work she does.
Thank you very much. I'm very pleased to be here. So we just have, we call it CFJJ to make it easier for ourselves. So Citizens for Juvenile Justice is a statewide nonprofit that does solely public policy advocacy. Our goal is and our mission is sort of gigantic. It's to ensure that our juvenile justice system is both fair and effective. And I should say that we also have an unstated goal, and that is to keep kids out of the system entirely. And it actually took me a while, I'm embarrassed to say as executive director, to kind of articulate that. And you sit there thinking about, is it fair if a kid is shackled? Is it fair if a kid is charged with this? Is it fair? Is the treatment, the rehabilitative treatment really effective? And then I started thinking of my own kids. Would I ever want my own child to ever dip into that system? Hell no. I would go to tremendous efforts to get the kid out completely. So why is my child any different from any of these other kids? It doesn't matter how much we try to improve the system. I think that the goal is to try to keep them out entirely so that they can move on with life and lead a healthy and productive life. One of the sort of issues is, how do we use the Constitution to accomplish our mission? And this is what Patty asked of me. And I stuttered, and the short answer is we don't. At least in any formal, explicit way. I think in the 10 years that I've been the executive director, I've only mentioned the Constitution when I get invited to speak to a law school class. It's not something I am doing on my regular basis. But the long answer, fortunately for me today, is yes. It's the principles embedded in the Constitution that I think that drives our advocacy agenda. And I would say it's more than just the Constitution. I think it's human rights, and I think it's international law. And so I'm going to try to give you a couple of concrete examples of the work we do and how I think the Constitution is what's driving that advocacy work. So Ducci has a client. She's got a case. She has going to fight hard and zealously for that client to have the best outcome possible. And then she's going to have another client, and that client's going to have the same barriers to success, and she's going to fight hard for that client. For Citizens for Juvenile Justice, we have no clients. We do no direct representation. But what we're trying to do is look at sort of Ducci's caseload and all the other cases that are floating around the Commonwealth and say, what are those barriers? What is it that Ducci hits her head across every time? And maybe her lawyering is just superb and she gets around it for that client, but what about the next lawyer or her next client? Maybe she won't be so lucky. Those policies and practices, those laws are preventing positive outcomes. And so we're looking at it from a systemic perspective. What can we break down those obstacles across the Commonwealth that the attorneys are just bumping up against? The target of our advocacy is extremely broad. So the classic form, I think most people think for public interest, right, is the legislature. You want to support bills, you want to oppose bills, you want to have appropriate budgets. That's absolutely true. The legislature and the governor's got to sign off. That's a huge target for us. But there's also many other targets, and I'm just going to mention some of them. One is the administrative branch. there's a lot of discretion within the executive branch. And if you can demonstrate to a commissioner that if they change their policy, they will be adopting best practices, they will be saving money, they will have better outcomes, and you provide some political support for that change, you can make an enormous difference. So, just classic example, Ducci mentioned how so many of the kids in our child welfare system, kids who have been abused, identified as abused and neglected, they go right into our juvenile justice system. And we have two different agencies, departments, that work on those two populations, the Department of Children and Families and the Department of Youth Services. And they sit within one secretariat in the executive office. So they have the common boss. There is almost no communication between those two departments, even if it's the same kid that's going back and forth. So one thing in this administration that's been done is that they've drafted and signed a memorandum of understanding between the two departments so that some coordinated work can be done. Again, it's not a change in law, it's not going to be in the newspaper, it's not going to be reflected really anywhere except in the practice. And people are going to start saying, this is interesting, our clients are doing a bit better. They're not bouncing around so much and falling in those gaps. The court, we do a lot of advocacy with the court. It's trickier. We don't have a court case. We're not making the legal arguments. So how do we do it? Well, we do it informally. You can meet with the chief judge. You can meet with judges. You can get feedback. You can share with them new research and policies and practices. You can try to encourage them to, attend seminars and conferences and sort of swamp them with information. But I think a classic example, and this is one CFJJ did not do, but the Youth Advocacy Department took the lead on, was kids were just always being shackled and handcuffed when they went into a courtroom, regardless of how serious the case. The Boston Globe had a great front page article about a kid who was skateboarding. And skateboarding a place, police officer said he wasn't allowed to skateboard. And his mom comes to the courtroom and his young son's completely shackled for skateboarding, right? Now, in Florida, they litigated that issue, and I don't know how many years it took, but a lot of years to resolve that. In Massachusetts, it was resolved by bringing the attention to the issue to the chief judge of the statewide juvenile court and having him change the policy. Again, right, big impact, but no court case. Another target is the police. Police have an enormous amount of discretion. They decide whether arrest or not arrest, or just talk to the parents, or make a referral. And so the degree that you're working with the police, educating the police, showing them other practices in other parts of the state that are very effective, that they can adopt, you are going to have an impact in that community. Schools, and I'll give some more examples of school policies, especially how they use police officers. And then there's a degree which is just the public, right? People who vote, you want to try to get them to vote for people who are going to be what we call smart in crime instead of just tough on crime. And to do that, we have to put out there in the public sphere, what are these best policies and why do they work? It's not always, it somewhat seems counterintuitive to people. Tougher sentences, that's going to reduce crime. Well, not necessarily. But how do we explain that so that the politicians can actually get elected? Ducci mentioned, really the fundamentals of the school-to-prison pipeline. And I'll just say, in Massachusetts, if you were to walk into a school, I'm going to pick on Springfield for a moment in Western Mass, an inner-city school in Springfield, the surroundings would be pretty shabby. The education would be often subpar. There'd be very little resources for special ed. Very little access to mental health services, and there would be a large law enforcement presence. You're going to have metal detectors, you're going to have armed police officers, You're even going to have probation officers who have a desk where they can, so the students come in and out, they can check in with their probation officers. In a city like Chicago, they've recently, one of the high schools in Chicago actually installed a booking center, a booking station in the high school. So they can be arrested in the hallway, and then they can have their fingerprints and photographs all within the school confines, right? You know, go to a leafy community in Massachusetts like Wellesley, you're not going to see any of those things. None of those elements are going to exist. But it's the poor kids of color that are in the inner city in Springfield. They're not in the Wellesley public school system. You visit a locked facility in Massachusetts, what do you see? You see at least 2/3 of the kids are kids of color. But you know that only about 1/4 of the youth population in Massachusetts is kids of color. And as Ducci points out, there's actually no evidence showing kids of color commit more crime or more serious crime. Furthermore, the kids you see are mostly from very poor backgrounds. The majority have been involved in the child welfare system in some way, and they have usually a long history of trauma. And finally, you're going to see kids that both failed at school and attended failing schools that failed them. And many of them have learning disabilities that were either never diagnosed or never addressed or both. You visit a jail, and you're going to see in Massachusetts, for adults, you're going to see 17-year-olds sitting in there. And you're going to see 17-year-olds who have committed their first offense, a nonviolent drug offense, and they're serving time with a full caseload of adults. You're going to see individuals that are serving life without parole for a crime they committed when they were 14, 15, 16, or 17-year-old. There's no opportunity for parole. Right, so something's wrong with these pictures. And many of them, I think, relate to the Constitution. The racial disparities raises the issue of discrimination and the Equal Protection Clause. The draconian sentences, like life without parole, raises the issue of Eighth Amendment and cruel and unusual punishment. The large law enforcement presence in schools that serve poor kids of color raise the issue of selective prosecution, right? You're not going to be prosecuted for that behavior in Wellesley. Why is it fair that you're prosecuted for being disruptive in Springfield? Inadequate education, I think that's probably more of a stretch because there isn't a firm constitutional right to an education. But again, you're looking at stark disparities in public schools between a leafy community of Wellesley and an inner city school in Springfield. The question is, what can a group like CFJJ do, somebody that's just focusing on public policy advocacy, what can we do to stop this school-to-prison pipeline? And I'm going to list 3 things. And the list could go on. So it's more to give an idea of sort of the categories of things that can be done. The first is not exactly sexy. And we always have a hard time selling this to funders, that this is part of our work. But the honest truth is that one of the first tasks of public policy advocates and lawyers is to collect the data. When you have a case with a client, you're looking at the facts. Right? What does the client say he or she did? What do the police say they did? What did the witness say? You're going to go out and measure the distances, who saw what, when, the lighting. You're going to look at the facts. Well, public policy is the same thing. What are the facts? If the theory behind this sort of mass incarceration of poor people of color, right, is that it improves public safety. Otherwise, why are we doing it? But is that in fact true? Are we improving public safety by locking up these kids and then later adults? Right. So the job of the advocate is to check it, is to hold that government accountable. So what CFJJ has discovered is that there usually isn't any data. That if the data is collected, it's not done in any meaningful way. So that it's collected in one way, it'd be like looking at apples, and in another way, the next jurisdiction over, it's like looking at oranges. And so you cannot compare. The other thing we've discovered is that the agencies often refuse to share the data that they have. And then finally, even if there's data, even if they'll share it, it's never been analyzed. So that's sort of the starting point for a public policy advocate. So what do we do about it? You actually could try litigation, and we have, CFJJ hasn't done it, we've done it with our partners to get information. But some of the big agencies like probation, the juvenile court, they're actually exempt from the Freedom of Information Act in Massachusetts. And so that just doesn't work. That's a no-go. You can try legislation, and we have filed bills that would force agencies to publish basic statistical data. But again, not a very sexy topic. Legislators aren't going to put that down of please reelect me because I forced agencies to share statistical data on juvenile offenders. It's just not. It's not really what's going to drive it. You can get, and we were successful in getting our sponsor to tack on language from our bill in an outside section of the budget, which is a sort of a sneaky maneuver. And so once you have a bill, there actually are opportunities to tack it on another bill, there's fun things you can do. But again, that's another avenue. You can also leverage other resources. There happens to be a federal act, the Juvenile Justice Delinquency Prevention Act, that provides states resources for collecting some data. So that's a good tool to use. And the last one to say, it's an example, it's very strange. You can hold a conference. Now, how is holding a conference going to change any policies or provide any data? The truth is, people love being invited to speak, and you ask, and when you come, could you please bring some of your data from your program? We'd love to know how you divert kids and who you divert, their race and ethnicity. Could you come and bring that for us, please? That's a very effective way to get data. Then there's also using the data that you've then collected to educate the public or the stakeholders, but that doesn't require any legislation. And so I'm going to throw out the example of we're doing a project with the National ACLU looking at school-based arrests. And we were doing a project with them years ago, and we realized some of the data that came in that 40% of all juvenile arrests in the city of Springfield, for any place, 40% of them were happening in school during school hours. It's the school to prison superhighway, right? And so then we said, well, let's look at the other major school districts, Worcester and Boston. And our report's not done, and I should be doing my work writing it. But I think that what it shows us so far is that it has very little to do with what the activities of the kids. They're basically the same in the different jurisdictions. It's not like kids are carrying guns and weapons in Springfield at a greater rate. It has mostly to do with how the schools use law enforcement, school resource officers. And what you find is that in communities where you have poor kids of color, greater proportions, you have greater proportion of law enforcement presence and greater proportions of arrests. And in other jurisdictions, it's the exact opposite. So the recommendations from the report, it's a question of school practices and policies. It's a question of allocation of resources, and somewhat a question of politics. Are the leaders in certain jurisdictions feel that their job is more secure if they say, we got law enforcement in schools, we're going to keep your kids safe? And can we provide the data to show that, in fact, the opposite is going to happen, that having greater law enforcement presence actually makes the community less safe, and having more of a connection with school officials and teachers and guidance counselors is in fact what makes schools safe. The last one I'm going to give an example is using data to lobby for legislative change. That's a traditional public policy. You draft a bill and you push it through the best you can. And what CFJJ is engaged in is a Justice for Kids campaign, and I have some handouts over there if anyone's interested. But basically, Massachusetts is a strange state. Does anyone know, when are you an adult in Massachusetts? What age? For criminal law purposes? Anyone know? It's 17, on your 17th birthday. You can't vote. You can't even use a tanning device without parental consent. You can't sign a lease. And you certainly can't drink until you're 21. But it turns out, if you are disruptive in school and you're picked up on this disturbing school assembly charge, you are going to be tried as an adult, and you're going to be sentenced as an adult, automatically. And as Ducci was talking about all the repercussions and collateral consequences of getting a juvenile record, adult is like that on steroids, right? It's much, much worse. And huge barriers to getting a job, getting housing, getting loans, etc. So we would like to see Massachusetts join the rest of the world and be 18. And that's what one of the examples I would say about human rights and international law. The world is 18. The vast majority of states is 18. And Massachusetts is just quirky. You know, we did this in the colonial era, it was 16, and Victorian era, we made it to 17, and then we just never thought about it since. And it's just sitting there. One of the issues of that's been really interesting and played out in the court is the brain research. And so, you know, Ducci was saying, you know, right, kids are not mini adults. We all know that they're different. And really the Supreme Court has embraced this in a much more substantial way in recent years. They've relied on the brain research to strike down the death penalty for juveniles. That's unconstitutional. They have used it recently to strike down life without parole for non-homicide cases for juvenile, again citing the fundamental differences of the children from adults. Of course, 18 is the age they talk about. No one says anything about 17. And how it's a difference of culpability, about their unique ability for rehabilitation. You don't know what a 14-year-old's going to look like when they're 35. They're not finished forming yet. And then I think a really interesting case came out this summer on Miranda rights, and talking about this 13-year-old who'd been taken out of their middle school and classroom and put in a conference room with 2 school administrators and 2 police officers and questioned. And the question was, is that police custody? And for an adult purposes, that's not police custody. But what the court said, from a child's perspective, did they feel free to walk out of that setting? Hell no. Right? So again, looking a little bit at how the differences of treating children versus adults. So a bill's been filed, and we're pushing for passage. I know I'm over time, so I'm just going to put in a plug for public policy work. If you go into direct litigation, and I did direct litigation. You know, I was a litigator for a while in civil rights. You know, a great way to get involved in public policy is to join a board of directors of a nonprofit, and that's in fact what I did. I joined CFJJ's board, and I served on their board for 5 years before I went into being a staff. And I'm going to say a couple of really great things about it is that you can engage in this discussion about systemic change. I think it makes you a better litigator, makes you think about the issues of your client. I think it can help prevent some burnout, because if you keep hitting your head against the same wall, it's nice to know you're doing something on the side to actually tear down that wall. It lets you see sort of the big picture, and sometimes you can get caught up in each case and the trees, and sometimes it's nice to see how the forest is out there and how it's operating. And you would have a huge amount to give with your background and your education in this field. So that's my personal plug.
Okay, thanks, Leo. Beth. So now you've heard from an individual public defender with cases and how to do work that promotes public interest, from somebody who doesn't litigate, who tries to affect policy from a different perspective. And Beth is a public defender who tries to do impact litigation based on clients' facts that are before her. In other words, she doesn't go into court and have a caseload, and she used to, but she no longer has a caseload. She takes all of these problems that all of the public defenders and criminal defense attorneys around the state say, I'm having this problem every day. This awful thing is happening all the time. And Beth figures out a way to bring a lawsuit and address it, or to save someone from something terrible that's going to happen to them. that will hopefully impact all of our clients favorably. I'm going to stand. Better on my feet than on my tush. So it was just a matter of time before the problem of homelessness among the universe of people that my agency serves presented itself to my unit, the Special Litigation Unit. And it was an issue in its own right to be confronted as an obstacle to justice for our clients. And my staff attorney, Ryan Schiff, who's also a Northeastern Law School grad, and I started with the shared notion that in light of the fact that homelessness itself is a pernicious institution, that its absence in the dialogue before our courts regarding basic human equality that's associated with full membership in the community must be on some level a silence that we were complicit in, and as to which we had a legal obligation to make newly perceptible to the courts. Now, my work has been exclusively in Massachusetts state courts, and I adopted the approach of the incremental win system that was epitomized by the NAACP Legal Defense Fund in their achievements in civil rights parity, and replicated to a very impressive degree by the efforts of lawyers like Ruth Bader Ginsburg in gender equality, advancing gender equality, and GLAD in working to eradicate discrimination against individuals based on sexual orientation and related issues. Mary Bonanno. The first opportunity to begin this consciousness raising with the Supreme Judicial Court here in Massachusetts on homelessness was in 2008 in a case called Commonwealth versus Nat 2. And in that case, the defendant had been squatting in a mobile home and was evicted by the new owner. And upon eviction, the now homeless defendant placed his belongings into 3 or 4 plastic trash bags, and a gun was inside a pouch in one of the bags and was discovered by virtue of a warrantless search. The issue presented in the case was whether society was prepared to recognize as reasonable the homeless defendant's expectation of privacy in belongings placed in plastic bags at the curbside where he was waiting for a friend to pick him up. I'm going to get some water. And part of my job at CPCS is recommending amicus briefs to be produced by CPCS. And I recommended to CPCS that we file an amicus brief in this case. I did not write the brief. It was written by an attorney named Lisa Kavanaugh. It was a magnificent brief. And what the CPCS argued was that by virtue of his circumstances, Nat 2 had used garbage bags, not luggage or moving boxes, and even though the bags weren't labeled or they weren't sealed with tape, they served the same important function as more traditional luggage or moving boxes, and that is to shield the contents from the public's view. Now, Lisa Kavanaugh directed the court's attention to a Ninth Circuit case that concluded that a homeless defendant whose belongings consisted of numerous closed boxes and plastic bags had retained an expectation of privacy in those belongings. And she also discussed a Connecticut case in which a homeless man was living in a makeshift home underneath a highway bridge. And although the Connecticut court declined to reach the defendant's claim that he enjoyed a reasonable expectation of privacy in his makeshift home, the court found that his use of the location as a home and the police knowledge that he regarded it as such were both strong factors in support of societal recognition that the defendant retained an expectation of privacy in closed containers left in the makeshift home. And then we waited for a decision. And the SJC's decision did not mention the word homeless once. It completely ignored the provocative question of what is a home for a homeless person.
Are 3 trash bags a home? And of course, we were very, very disappointed, but we had seeded the soil. And that is one of the most important things I want to talk to you about today, is we planted in the mind of the court our notion that homelessness was an essential factor in the Fourth Amendment and state constitutional calculus. And as advocates, we accepted that we planted today and we weren't going to reap today. But you seed the soil in your pleadings and in your brief and in your oral argument and in your discussion with colleagues, and then you wait for the opportunity to build on that. And so the next opportunity came in 2009 with a case called Porter P., Commonwealth versus Porter P., in which the appeals court held that a homeless family had no reasonable expectation of privacy in a room allocated to their use in a family shelter for homeless families. And the SJC took further appellate review. And I wrote an amicus brief for CPCS and other amici, including ACLU, and I think Harvard was also in the brief. And I built on this NAT2 seedling, and I argued that the growing plight of homelessness presented a challenge to jurists, to the courts, to rise above these archaic legal assumptions that are embedded in the context of search and seizure jurisprudence, which provides that each citizen has a house and each citizen has some minimal access to personal property. And I argued that homeless citizens are entitled to no less protection under the Fourth Amendment than those in our country who do have housing, and that the failure of our appeals court in this case to afford the same robust Fourth Amendment and Article 14 protections to the homeless juvenile and his family in the shelter dormitory as would be applied to patrons of a hotel or to students in a college dormitory created an unacceptable and invidious classification between the rich and the poor. And the SJC held that, quote, the room that the juvenile and his mother shared at the shelter was a transitional living space, but it was nonetheless their home. The juvenile slept and kept his belongings in the room. He and his mother possessed a key to the room. And the fact that the shelter staff members had a master key and could enter the room for professional business purposes, quote, does not diminish the legitimacy of this privacy interest in the room, unquote. So I don't know how many of you have taken classes with Carl Clare, but when we were students and we used to finally sort of get it, what he was talking about, he would say, now you're cooking with gas. So I remember when we read this case, we were like, now you're cooking with gas. So then, in late 2010, I litigated the appeal of a homeless man named John Canadian from the finding of a violation of probation. Now, Canadian had been convicted of a sex offense, and after concluding his term of incarceration, he commenced probation. And as a mandatory consequence of his sex offense conviction, this guy had to wear a GPS monitor during the entire probationary period. Now, the monitoring apparatus that the Commissioner of Probation, yes, that guy who was indicted, Commissioner of Probation, leased to distribute to probationers required the apparatus to be plugged into the wall and charged 8 hours every night. And the individual who wears this apparatus can't be more than 10 feet away from it. So this meant that homeless individuals on probation for a sex offense either had to find a place to charge their GPS cell phones every night, all night long, or they were just going to be out of luck. The probation department filed a surrender notice against Mr. Canadian for failing, as a consequence of his homelessness, to be on GPS monitoring. Now, this case was a quantum leap in our litigation efforts because now we were forcing the court to contend with the consequences of homelessness itself. Not like Porter P. or NAT2, where we're addressing the question of what are the reasonable privacy expectations of homeless people? What can they reasonably assert? Now we're saying, what happens when homelessness itself is the obstacle to this individual's ability to meet the terms and conditions of the law. And on behalf of Canadian, we presented evidence at a hearing, at a surrender hearing. And we looked to establish 3 key issues on the record that would force the court to contend with the consequences of homelessness. Our goal was to force the court to contend with the consequences of homelessness. We actually asked the trial court to contend with the consequences of homelessness, and I'll read you what the SJC had to say about her. But the first thing we did is we established that Mr. Canadian's homelessness, like so many other offenders classified as level 3 offenders by the State Sex Offender Registry Board, was an unavoidable consequence of his sex offense conviction, and we put in articles into evidence to that effect. And then the second thing we did is we demonstrated that Mr. Canadian had worked diligently and in good faith to try to resolve the technological impasse that he faced, the employability impasse that he faced, and the housing impasse that he faced. We put on a lot of witnesses who knew this guy, who had worked with this guy, and who had something to say about his circumstances and the fact that they replicated all over the state because of these laws. And finally, we established that there was not one homeless shelter in Massachusetts that permitted homeless offenders to charge their GPS cell phones overnight, because there were so many homeless sex offenders who had to wear GPS devices that it would have overwhelmed the resources of the homeless shelters. Their utilities would have just been sucked like a giant magnet by the commissioner of probation who was indicted. And the SJC delivered. The court acknowledged that the defendant's unrebutted witnesses, quote, provided substantial evidence about the extraordinary obstacles facing sex offenders attempting to secure employment, unquote. And then the court turned to the crisis of homelessness among that population which we had raised, and the court noted that the Boston Globe had reported in 2006 that 65% of level 3 offenders in Massachusetts were homeless, and that in 2007 as many as 74% of level 3 offenders in Boston were homeless. And given this, and the fact that Mr. Canadian had in good faith diligently explored other living arrangements and alternative GPS technologies to no avail, the court held that the defendant could not be at fault for failing to comply with GPS monitoring requirements. And in these circumstances, said the court, quote, where there was no evidence of willful noncompliance, a finding of violation of the condition of wearing an operable GPS monitoring device was unwarranted and is akin to punishing the defendant for being homeless. So not only did we make the pernicious institution of homeless perceptible to the SJC, but we made the defendant as a human being perceptible to the SJC, because footnote 11 reads as follows, quote, throughout the proceedings, the judge was both dismissive and condescending in her treatment of defense counsel, the evidence ably presented on the defendant's behalf, and the defendant's circumstances. Such demeanor creates an unacceptable appearance of bias and partiality, unquote. So we now felt that in the course of these cases over the past few years, we had begun and had developed a serious dialogue with the court on the realities of homelessness, one that we hope will bear fruit as we continue to push forward in new directions. And I have a quick postscript for you, which is that last month, Ryan Schiff and I won a challenge to a state law making it a crime for a level 3 sex offender to live in a rest home or a nursing home or other long-term care facility. And one of the things we argued was that a law forcing our indigent plaintiff from the rest home where he was safe and cared for and loved would render him homeless. And the SJC acknowledged this fact and dropped a footnote which read, quote, as we noted recently, the The practical reality of homelessness faces an increasing number of sex offenders, unquote. And the citation was Commonwealth versus Canadian. Thank you.
Okay, I'm obviously not going to talk 15 minutes because it's already 1, and I want to give you some time to ask some questions. I'm just going to say a couple points about public interest work from my perspective. You've heard it from law reform people, you've heard it from the people who work on impact litigation and individual cases, all doing public interest work. And a lot of you that have been coming to talk to me have asked the question, well, how do you afford to do it if you're a public attorney like you? How do you make it work? And the short answer is that it's absolutely workable. You just are not going to earn the amount of money that you'd earn if you were working at a big law firm in Boston. You're not going to charge clients when you're doing public interest work the fees that you would get in a large law firm. The satisfaction is tremendous. The fulfillment is tremendous. And you can go into a private firm. You can become a bar advocate, which are the people around our state that do criminal defense work and bill the court for their hours, and that's public interest work. You can work for agencies, nonprofits, and do this kind of work, and you can have your own small law firm, and you won't make the fortunes and the millions that you might make in a big law firm, but you've got a lot more going for you because you've got genuine happiness, you've got clients whose lives you've changed and who you've saved, and it feels wonderful. And I wouldn't trade it for the world because it's such a good job, and it doesn't pay a lot of money, but you know what? Compared to what most people in the world make, I am like fabulously wealthy because I make plenty of money to live on and live happily, and it's a fraction of, most lawyers would say, oh, forget it, but it works. You can do it in a private law firm. And the things you can do in a private law firm, you can join boards of directors, you can contact and organize committees, you can do this kind of thing. Your options are endless when you're in a private law firm because you can help control what you do and you can control your hours and you can join all the boards of directors you want and you can work for clients for free. You can bring civil rights cases and oftentimes get attorney's fees if you're successful in a civil rights case. So you can be in a big firm and decide you want to do a civil rights case and still get your attorney's fees. So even if you want to work in a large firm and make big bucks, you've got plenty of opportunity to do public interest work. And believe me, my friends who are in big firms who do it say it's their favorite cases, their best work. The lawyers who work at Goodwin Procter who agree to take a death penalty case, it's always their favorite case. The lawyers that work at another big firm that agree to take a prisoner's rights case, it's always their favorite case. So don't forget about public interest work. These guys do it full time, they're great. You can do it part-time and feel wonderful. So I won't say anything else about it. Let's just do some questions because it's already like 10 after 1, okay? Nobody has any questions? Yes, sorry.
I can speak loudly as well. I really want to thank all of you for your presentation. It's definitely helpful. Tucci, I think you did a presentation for your advocacy group, Bold Teams, Know Your Rights.
Yes, I did.
Education is key. And so my question is, looking at the youth development and all of the health, safety, community education, all the elements that you need for proper youth development, and we're talking about communities where young people have limited access to health and subpar education, how do we go about holding these systems more accountable? Like my biggest problem in my neighborhood is that we have police officers that don't live in the neighborhood. We have a Boston police union, just ridiculous. We have teachers that oftentimes don't live in the neighborhood. Our judges and lawyers that don't live in the neighborhood. Even our doctors don't live in the neighborhood. So we have a young person that's a problem, but it's not their problem. So they can just shift them along. Teachers can shift it to the police, and police can shift it to the courts, and then it becomes, your problem. So, how do we go about accountability, or have you guys dealt with any cases where, because my biggest concern is they're not a part of the community, so they just view these young people as a separate entity or separate issue when it's not an issue of all the children or all of our children, like you had mentioned before. So.
I mean, you touch and highlight the problem, and this is what we face every day. And I think part of, what we can do is sort of what I was talking about, the work that we do in our offices. So, the more people that we have who do this work and who are experienced, and I touched on this briefly, in our offices, part of it is we have experienced people who have been doing this work. Because they're new offices, hired entry level, but I think moving forward, the goal will be to have people who, start in a district court where they get the foundation for those legal skills, and then they come into a juvenile office and they can build on those skills by, getting experience doing juvenile work, working with the collaterals, working with Department of Children and Families, working with the Department of Youth Services, working with community-based organization. Part of it is educating our communities and, teaching them about the detrimental effects of youth being exposed to the juvenile justice system and what it really does. It's, Lael mentioned that part of the push is public safety. We want to keep our communities safe. But locking up children, especially, the children, we have disproportionate rates of children of color in our systems, are not keeping our communities safe. There's studies and research that has been done that's showing that even though, we are locking up more and more children, over the recent years, the rates have gone down. So I think, part of it is getting you guys to come to our offices and do this kind of work, or as Patty mentioned, in other areas of public interest in doing the work. But I think key component of it is education, and part of the goal for my office is to reach out to the community, work with the community-based organizations to see what community-based services we can implement in the community to make sure we're providing services in the community for our children. And for some people, like, oh, they're not getting services in the community, they'll get services in the Department of Youth Services, but they're not. And to keep them in the community and hopefully ensures that they'll remain in the community and be successful members of our society.
I just would add, there's a great anecdote. Gail Garinger is a judge, and it was a juvenile judge, head of the chief for Middlesex County, and then she left that job to become the child advocate for Massachusetts, which is a new position, reports directly to the governor. And she's very great that she shares this information, but she says when she was a sitting judge, she would order kids to be held in detention, held in confinement while awaiting bail, because she worried about their home and she didn't know quite what they were going to do between now and the next day, and at least they would get, they would get some health care and they'd be safe. And she saw it very much as a benign thing, not great but not bad. And it wasn't until she left the position of being judge and she met all these advocates, and we were all inundating her with studies and alternatives to detention, and in fact that there's real harm to detention and they're much less likely to ever graduate high school, just the whole kit and caboodle. And she's like, oh my God, this was out there, but I didn't see it. I didn't hear about it. I didn't talk about it. Judges conference, we never discussed this stuff. We talked about how you fill in the form, in arraignment detention. Make sure you check that box, because the clerks don't like it if you don't check that box. So, I just echo Ducci. A lot of it is public education. I think, if people get the information, I think a lot of them can process it and incorporate it. But they're living a little bit in a vacuum, their little bubble. Yes?
I have two questions. One is regarding the agencies that are exempt from the Freedom of Information Act. Why? What are the grounds for their exemption?
So the act is a legislation, and interesting enough, the legislation was passed saying that agencies have to share information. There were two exemptions. One was the legislature; they don't have to share their stuff. Funny how that works. And the other was the judiciary. And I think, to be honest, I think part of the judiciary was they didn't want people trying to get the judge's notes and things to do that that might be incorporated and kind of cause chaos. But they unfortunately it's read broadly enough to include just basic statistical data, like how many kids are arraigned a year, How many of them are placed on probation? How many are found in violation? That information for 10 years was not shared at all.
And now?
So, well, we had a commissioner of probation that was that left and has been indicted, and we have and that's part of the advocacy, right? To make sure try to connect the press to the problem, and we have a new probation commissioner who's actually the one who should have gotten the job back in 1999, who has a very different approach and is all about transparency. And is also willing to engage in collaborative initiatives and is a sea change. So I guess the other thing I would say is leadership plays a ton. Who is the superintendent of the school district? Who is the commissioner of Department of Youth Services? Who's the commissioner of probation? God, I don't think I appreciated what an impact those people have. But it also means as advocates, it's our job to build good relationships with those people. And I don't mean just to be cozy buddies, but hold them accountable, but do it in a partnership. And also support them when they are willing to take the chance to make a change, that we don't let them fly out politically on their own.
So that actually leads to the second question. What are the procedures around the law enforcement presence in schools? Like, who decides that a booking, like people can get booked for that school? Who decides how many police officers can be there? And what are the things around that? Like, how can we try to curtail that?
I think, at least for Massachusetts, it's really a decision that's made jointly between the police department and the schools. So in some school districts, the money is for police officers comes out of the city budget for the police, and they're just assigned certain schools, and there's some negotiation of which schools and how much. Some school departments, they actually pay for the police themselves. So they're paying part or full salary. So the Boston police, well, that's just in Springfield, the Springfield police that are assigned to the schools are being paid by the schools.
So that's coming out of the school budget?
It's coming out of the school budget, right. So it's the politics of the school and the school budget, and the politics of the city and city budget. And then, so the mayor's role is going to play, the school committee's role is going to play a piece of it. But it's not really driven by the legislature in any substantial way.
Okay.
This question for Beth. What kind of partnerships do you create in order to identify the cases that you're going to do the litigation for?
I connect with the staff attorneys at CPCS. I get a lot of my work from bar advocates who are doing indigent representation. I talk with people who are connected with different organizations who hear about cases and issues that are kind of percolating up. It's a strange job because it's feast or famine. There are times when, we're just extraordinarily busy, and then there are other times where it can get a little lean, because a lot of it has to do with how well we maintain connections with people who are in the courts and are essentially our eyes and ears. We're trying to deal with systemic practices that are, obnoxious. And so if no one tells us about it, we don't know about it. And so we do, I used to call it my Hunter Thompson road trips. Used to take a hapless student with me, like driving 80, to different places to talk with lawyers about what was happening in the courts in which they served. And sometimes unbelievable stuff would just come up anecdotally, which formed the basis for further investigation and litigation.
Yes.
So my question is, there seems to be a lot of places or opportunities for transparency, and conversely a lot of opportunities for obfuscation. What branch is the police technically part of, and is there in Massachusetts of people that you arrest. It sounds like for sentencing, once it's within the courts, there's a black box. But in terms of the actual racism of the police and all that bad stuff, what ways do we have to put a break on that? And then how are your three organizations, if at all, working on doing that, either by passing local legislation, state legislation, rallies, whatever?
Well, I can start for CFJJ. So we litigated, we being the royal we, not me, but the National ACLU, took on City of Worcester School Department and the police for refusing to turn over information about school-based arrests. And they ultimately turned over the information. One thing I should just point out is that our Public Records Act says that you can charge the person seeking it, reasonable fees. I think one school department claimed it would cost $16,000 to photocopy the police incident reports for 1 year. So I don't know how many, they thought they were arresting, and if it was gold-plated photocopies, by the police chief at time and a half. But so I know that they don't fall, they certainly don't fall within the judiciary. They're not exempt from Public Records Act. They do have to dedact, and we don't want it anyways. We don't want the name of the kid or any information that way. In terms of race ethnicity, though, that's a really interesting one. The FBI collects data for juveniles and adults on the number of people arrested, their age, their gender, their race, ethnicity, and the type of offenses. They have certain categories. And in Massachusetts, for some peculiar reason, the police here count black, but not Hispanic. So and you can't be both. You got to be one or the other. So if you look at the police reports, it looks like there's not a huge disparity. There are a lot of whites who are arrested, but included in whites are Latinos. So then the court, they do include it, but again, it can't be done jointly. You're going to be identified as they call it black, or you're going to be identified as Hispanic, but you can't be a combination. So it makes it very, very tricky. And then in terms of getting them to report, we have this federal act that says to states, including Massachusetts, hey, we can't tell you what to do, but we can bribe you. So if you do what you want to do with your juvenile justice system, but if you want this federal funding, you have to do various things. And one of the things you have to do is you have to identify racial disparities at every key stage. So at arrest, at arraignment, or diversion, at arraignment, detention, finding of delinquency, and the sentencing. And so that we did file a bill that is not being done. It's not being done consistently. And so we did file a bill saying everybody has to do this. And this is the matrix. You got to use a specific matrix. You can't make up your own. So that is still pending, and that we have taken some language out of that. And it was mentioned as sort of this outside budget language has created a new commission, and this commission is now tasked with looking at this as well. So I don't know if that answers it, but it's much more complicated than you think it would be. And the truth is, the police will say, well, it's really hard for us. Well, a booking sheet, right? I mean, what does it have on there? It has race, ethnicity, it has height, eye color, tattoos, scars, right? And, that's all entered. So how hard can it be?
And in Boston specifically, it has black/N, or I assume black/age. So
Oh, it's there, yeah. It's just not translated from that form to anywhere the public could get access to it.
Let's just do two more because it's almost time.
I have a question for both Eugene and Lionel. So I've done a co-op in CPCS, which is amazing. And one of the things that I noticed was that the collateral consequences for people after serving their sentences can be huge in terms of finding jobs, entering programs, and trying to go back to school. So I was just wondering what YED does in terms of juveniles trying to move forward after serving their sentence. And then my question for Lal was whether CFJJ has done any work around court reform considering the impact that can have on juveniles.
So in terms of your question about what we do after a youth has served their sentence, typically our representation, say for example somebody is placed on probation or committed to the Department of Youth Services, that doesn't happen often in my office. But we represent them at, the Department of Youth Services has something that's called a staffing, where they determine the amount of time based on the offense and what treatment program they're going to go to. So we represent them through that process, and oftentimes, because of our relationships with our clients, we keep in touch, and they, in many instances, have relationships with a social service advocate in our office. So, for juveniles, in terms of jobs, it's a little different, because if you're adjudicated delinquent, it's not considered a conviction for purposes of many different things. So, it doesn't have the same, in some instances, doesn't have the same barriers as adults. But if there are problems with, housing or getting back into school, we do assist in those. For the school piece of it, we do a lot of the advocacy ourselves. In Roxbury, there's the Ed Law Project, which is a collaboration between the Youth Advocacy Department and the Children's Law Center in Lynn, and they do education advocacy as well and provide resources for attorneys. There's only 2 people in that office, so unfortunately they can't do all the education advocacy, but they provide training and assistance and advice to those people who are doing that work as well. When I've had clients in the past who have had issues around public housing, we've made referrals to different organizations. I know a lot of law schools have clinics that help with those kinds of issues. There's the Greater Boston Legal Services. So there's different, unfortunately, sometimes we can't do it all, but we have the ability to refer to the appropriate agencies who can do those kinds of things and help with that kind of advocacy.
In terms of CORI is the criminal offender record information. So if you're arraigned or formally charged, it's now showing up in your record. And there was this big push for CORI reform for adults, and it didn't include the element for juveniles. And the time is ripe to do that. So there is legislation that's percolating. There was a hearing last Tuesday, the Joint Judiciary Committee. And I think we're looking at, does that need to be tweaked, and can we try to push it this legislative session? You guys are too young to remember this, but there was sort of a headline news. There was a young woman who was accepted at Harvard College, and she was asked, have you been convicted of a crime? And she said no. And she had been adjudicated a delinquent, and I don't remember, one of the, Carolinas, I think, for killing an abusive parent. But she'd asked her lawyer. Her lawyer said, no, you don't have to say convicted, because legally you weren't convicted. You were adjudicated. Harvard found out about it, and they accepted her. They withdrew their offer of acceptance. And then Tufts came in and accepted her. but it was, that just was sort of highlighted the problem. And not everybody has got that problem, but it's really very difficult for people to move forward. Yes.
This question is for Ms. Eisenberg mostly, but for all of you. I really liked your idea about planting seeds, and the example that you gave was planting a seed within the context of an official legal proceeding. And then you gave an example about planting seeds outside of official legal proceedings with legal elites, you might say. And I'm wondering about what your all's experience tells you about how those two interact when you're thinking strategically about advocacy, and what your experiences tell you that the relative importance of those two are.
Yeah, my work is very compartmentalized. I'm charged with the job of litigating. And if there's a better way to advocate for change, it's usually done by someone else in my agency. I wonder if I'd be any good at it, actually. I mean, you know, I'm very used to the formality of the court. If I actually had to sit down and talk with someone, I'd probably puke. So I'm not sure. You know, there are people who do both and who are really very gifted at doing both. And doing both is better than doing one, because sometimes what you need to get people on board is not to sue them. Sometimes people want to be sued. I mean, there are people that we've sued who took a very laissez-faire attitude about it and thought, well, you know, sue us. So I can't really talk to that. I mean, I think that Lael is probably the person who can answer that better than I can. All I can tell you is that I enjoy doing the litigation piece of it.
You know, I think there probably is a disconnect between the two worlds, right? I mean, I think if we knew more what was happening in the court, what challenges, then we would see opportunities to put a plug in from our end, and then vice versa. I think we're very lucky in Massachusetts in the relationship between YAD and CFJJ. So the head of YAD is a board member of CFJJ. So he's sitting in the discussions about policies, and then he hopefully is sharing with us some of the discussions about litigation. And I'll just throw out one example is life without parole for juveniles. So YAD has sort of two approaches to it. It has a public policy approach, which is file a bill, try to pass a bill, you know, circulate an excellent report that talks about the kids who are now serving and, you know, all of that, and also a litigation. You know, who are those individuals serving now? What are the opportunities? There's been lots of action on the U.S. Supreme Court level. How do we also apply the Massachusetts Constitution? And so I think that's like a very, you know, that's probably the best example of a totally coordinated litigation public policy. But I think you raised an issue, which is I think there's probably a lot more opportunities that sometimes we're missing.
Okay, everybody, so that's it.
One thing. I want to thank Patty for bringing together an absolutely fabulous panel for us here. And I also want to again thank Patty for being an absolutely wonderful Daynard Fellow for us these 3 days.
Thanks, everybody. And you know what? These are 3 great co-op jobs right here. YAD and CFJJ and the Special Litigation Unit at CPCS. So try them out. You'll have a blast. Thanks.
If I could just say, there are some brochures about the Youth Advocacy Department over there, and I have some community notebooks that were put together by the Youth Advocacy Department. This one is the education notebook, so feel free to pick up some materials.